Ja, ich möchte Sie ganz herzlich begrüßen zum Tag der Mediation 2021. Mein Name ist Franziska Müller-Tiberini und ich bin die Präsidentin vom SDM. Unser zweites Roundtable-Gespräch heute widmet sich unter dem Titel A Comparative Legal Perspective at the Mediation Practice in Faraway and Neighborhood Countries will provide inspiring insights into the state of the mediation and market in Switzerland. Ein rechtsvergleichender Blick auf die Mediationspraxis in fernen und benachbarten Ländern wird anregenden Einblick in den Stand des Mediationsmarktes in der Schweiz. Ich hoffe, wir haben eine tolle Diskussion und ich freue mich auf die Referentinnen und Referenten. Herr Jean-Christophe Barth, er wird diese Panel-Teilnehmerinnen und Teilnehmer noch begrüßen und sie auch vorstellen. Mir bleibt die Arbeit oder das Vergnügen, Jean-Christophe Barth vorzustellen. Jean-Christophe Barth ist Wirtschaftsmediator und Mitglied des SDM-Vorstandes. Er hat bei Unternehmen wie Bombardier, SBB, Citibank, SGL, Carbon Erfahrung im Projektgeschäft und zahlreichen Vertragsverhandlungen gewonnen und ist seit 2018 Executive Director vom World Association of PPP Units and Professional, die sich der Verbesserung von Public and Private Partnerships verschrieben haben und diese Woche zeitgleich mit dem Visit von Putin und Biden in Genf einen virtuellen Weltkongress mit über 750 Teilnehmerinnen und Teilnehmern aus der ganzen Welt organisiert haben. Jean-Christophe ist außerdem ein unabhängiges Verwaltungsratsmitglied und gehört dem VR-Netzwerk APIA Swiss an. Er hat letztes Jahr die European Champions Alliance gegründet, die europäischen Technologie-Scale-Ups zum Durchbruch verhilft und die Abhängigkeit von den asiatischen und amerikanischen Märkten verringern möchte. Jean-Christophe hat nach der Ausbildung als Bankkaufmann in Lausanne, Straßburg, Tübingen und am Centre Juridique Franco-Allemand Jus studiert und später am ISSEC und Mannheim Business School einen Executive MBA erlangt. Er ist verheiratet und er lebt in Genf mit seinen Kindern und einem Jagdhund. Jean-Christophe, ich danke dir vielmals für das Engagement, auch des zweiten Roundtables heute, den wir veranstalten können, weil du dich so engagiert hast. Vielen Dank und the floor is yours. Welcome.
Thank you very much for these kind words, Franziska. Franziska is the president of the Swiss Federation of Mediation Associations, with the umbrella organization for all mediation organizations in Switzerland. And it's because of that that we want to also do something special on the International Day of Mediation. And this is why we thought it would be a nice idea to look at the perspective of our neighboring countries, and also something a bit more exotic for us here in Switzerland, looking at the Turkish mediation practice. And I'm very happy that Vahit accepted to join us for that. I'll start introducing him. Professor Dr. Vahit BICAK is the CEO and founder of Just and Fair Mediation. He's an accredited and skilled mediator for about 8 years and a qualified attorney with 30 years of experience in handling both commercial and private disputes. He's certified as an international domestic mediator since 2013. He has mediated more than 200 disputes around the world and in Turkey, with disputes including complex cases with international organizations, multi-party disputes, and online mediation. So it's a true pleasure to have somebody with such an experience who's also teaching at University of Ankara share his experience with us today. I suggest to not make the intro too long. We'll simply dive in and I'll present the other panelists as we make progress. Vahit, you have the floor.
Okay, thank you, dear moderator, dear participants. I'd like to welcome all participants from different parts of the world to the seminar on the comparative legal perspectives at the mediation practices. Thank you for coming and joining us today. Also, I'd like to thank the team of the Switzerland Federation of Mediation Association for organizing such a global event. And I will be talking with you today about mediation in Turkey. How does it differ? So mediation has been formally developed in Turkey. In 2012, mediation as a way of formal dispute resolution methods has been introduced in Turkey by the Code of Mediation in Civil Disputes, which was entered into force on 23rd June 2013. So since then, mediation practice is becoming more common, in particular in relation to commercial, employment, and consumer disputes. Although pro-mediation provisions existed on Turkish Civil Code before the year 2012, there were virtually no mediation practice in Turkey. Turkey didn't see a widespread adoption of mediation until the implementation of mandatory mediation at the beginning of 2018. The state of affairs changed drastically in 2018, 19, 20, and 21, when legislation has been introduced to extend the application of mediation as a dispute resolution mechanism by making it mandatory and precondition to filing a lawsuit before the court in certain cases. Mandatory mediation for labor disputes has been entered into force on January 2018, and mandatory mediation for commercial disputes has been entered into force on 1st of January 2019, and mandatory mediation for consumer disputes has been entered into force on 28 July 2020. And Turkey has signed and ratified the Singapore Convention on Mediation, which will come into effect on 22nd of October 2021. Next, please. So if we look at the statistical data, so we will see that voluntary so far 500,000 application for voluntary mediation has been done, and 98% has been concluded as an agreement. That's a huge rate. And mandatory labor disputes over 1 million, and 60% of them were concluded as agreement. And mandatory commercial dispute mediation, 364,000 files, and 53% of them by agreement. And mandatory consumer disputes, 60,465, and 56% of them has been concluded by agreement.
Vahit, those are all mediation cases on the left side of the column. That's the number of cases?
Yes, that's the number of cases, and percentage is shown. That means so far, so from the beginning of mediation process up to now, total mandatory mediation files, 1.5 million, and success rate or agreement rate is 54%. And total voluntary and mandatory mediation files so far from the introduction, 38,000, and success rate, I mean agreement rate, is 64. Next, please. So in all categories, as you see, agreement rate is more than half of the case. So the numbers are very high because the population of Turkey is 84 million. And facilitative mediation is adopted in Turkey. However, under certain conditions, the mediators can make proposals, and Turkish legal system allows judges to encourage parties to mediation. When a party doesn't take up such offer, the judge hasn't the ability to implement financial consequences. Authorization to mediate, mediation should be handled only by mediators accredited by the Turkish Ministry of Justice. And Turkish law requires mandatory mediation in labor, commercial, and consumer disputes at the moment. And no need for mandatory presence of the lawyers of the parties. And opening speech of first meeting should be conducted. The law dictates that at the beginning of the first meeting, in which the mediator explains to the parties the function and how to conduct the mediation. So mediation process protects confidentiality and professional privacy. Mediators cannot be called as witness in a trial. So evidence submitted during the mediation process cannot be used in the trial. So mediation proceedings can last up to 4 or 8 weeks, depending on the nature of the disputes. For labor disputes, it's 4 weeks. On commercial disputes, it should be completed within 8 weeks. After which, the mediation file is closed and time limits for opening a court file start. So those not participated without reason in a mediation process are required to pay court costs in a subsequent litigation. And mediation agreement is directly enforceable. So enforceability of mediation agreement drawn up at the end of mediation process is similar to a verdict given by a court. So one should note that to have a mediated settlement agreement enforced in Turkey, it will be useful to have them enforced by a mediator who is accredited by Turkey Ministry of Justice. So co-mediation model for disputes between Turkish and foreign parties will be a good model to encourage the use of mediation and increase the chances of settlement. Next, please. So under Turkish law, only trained and accredited lawyers can become mediators and be listed in the Mediators Register of Ministry of Justice. Participating and successful completing the requisitive 78 hours of training is compulsory first step to become a certified mediator by the Turkish Ministry of Justice. The second step is participating in the competitive national mediation examination, in which around 30,000 candidates complete and only 5,000 are successful in each 2 years. At the moment, there are 16,000 mediators certified, accredited, and registered by the Ministry of Justice. So the mediation center wasn't enacted with a cross-border perspective, and in particular that it explicitly requires Turkish citizenship for being a mediator in Turkey. However, the law allows appointment of co-mediator who might be foreigner or international mediator. So in order to become a mediator in Turkey, one must have a law degree from an accredited university, at least 5 years professional experience, completing a mediation training at least 84 hours, as well as refreshing training every 2 years. And training necessarily requires theoretical components to ensure mediators understand legislation, affecting them, and as well as role-playing. So passing a national mediation written and oral examination, registration at the Minister of Justice, Turkish citizenship, and person should be shouldn't have criminal record and other things which may have unqualify him. Next, please. So, key opportunities, challenges, and developments anticipated in Turkey in the near future. Although with great slowness and with great effort, mediation is now known and accepted as a way of dispute resolution by individuals and companies. And family disputes are expected to be included in the list of mandatory mediation. And it is hoped that mediators training course will be revised and updated, providing more fruitful training than the current ones. And accreditation law of mediation centers is expected to be enacted. So more controls expected to be introduced both on mediators, mediation centers, and mediators training institutions. So more steps towards institutionalization of mediation and its embodiment in the civil procedural system will be taken. Wider use of mediation will be encouraged so that it eventually becomes a complementary dispute mechanism means, and court workload will be reduced and resources in the administration of justice will be saved. A regulatory provision could be envisaged to provide tax relief and tax breaks for lawyers who assist their clients in mediation. Thank you for giving me a chance to make a presentation, and thank you for listening.
Well, thank you, Vahit, for having shared this absolutely interesting insights into the Turkish mediation landscape. I think the one thing that struck me most was the level of mandatory mediation, also the incentives that has been given by the state in order to facilitate and incentivize people to resort to that form of dispute resolution. I mean, the tax exemptions for lawyers is just a very creative way also to foster acceptance for that. I don't know, anyone on the panel who would also like to react on that? If not, let's not lose time. Let's proceed, because we have a lot of really interesting people in this panel today. Next, I'll be introducing Ulrich HAGEL. So Dr. HAGEL studied law and business administration at the University of Bayreuth. And after having worked as an attorney at law in Stuttgart, he joined Bombardier Transportation, now Alstom, in 1998. As global head of litigations and general counsel office, he's working conceptually on conflict management processes and tools, but also management processes and tools that help to lead complex disputes and negotiations, ADR processes, arbitration, and court litigation. Since 2010, he's also a partner at Konsenzkanzlei in Berlin. Dr. HAGEL has published several articles on conflict management, contract management, and compliance. He's a co-editor of the German arbitration journal, SchiedsVZ. He's a founding member and member of the board of the Roundtable Mediation and Conflict Management of the German industry, which we will hear more about now. I have some echo here, so if you could maybe cut your microphones. He is also a member of several advisory boards, the German Arbitration Institute, DIS, and the online magazines Anwaltsspiegel and Dispute Resolution. Since 2014, he's an academic director of the MBA program of International Commercial and Contract Management at Dresden International University. And it's a true pleasure for me in particular to have invited my mentor in commercial mediation, because we used to be colleagues. And I think it's also thanks to Ulrich's help that I found the way, because mediation is the way. Ulrich, it's your turn.
Okay, thank you very much, Jean-Christophe. It's a pleasure to participate on that panel. And I'm going to introduce the German perspective to mediation. And I'm going to start also with a legal framework there. I guess as Turkey, we have started in 2012 looking into a Mediation Act, which was also published in that year and went into force in 2012. This is based on the EU directive of 2008 on mediation. A couple of specific items under this Mediation Act. So first of all, under this Act, mediation is possible for all kinds of disputes. It is defined as a structured and confidential negotiation process under the lead of an independent mediator with no authority to decide on the dispute. We don't have any mandatory mediations in Germany. It's all voluntary. We have the confidentiality only for the mediator unless the parties agree otherwise, which usually they do. However, this confidentiality of the mediator is not only a right he has, it's a duty. So he cannot even talk. He has a Zeugnisverweigerungspflicht. Then we don't have any qualification requirements for a mediator regarding age, profession, or registration. Nothing is needed there. You don't have to be a lawyer. You don't have to have a certain age. You don't have to have German nationality. You can act as a mediator and fall automatically under the Mediation Act if you do a mediation in Germany. Mediator is responsible to be sufficiently trained and educated and has to inform the parties on their request on the education and the experience. Usually the parties don't ask for that. That is at least my personal experience. There is under German law a possibility to have a so-called certified mediator. Certified is a little bit misleading because there is no certification authority. It is a self-certification. Everybody can certify him or herself. However, there are preconditions, and that is you have to have an education according to a regulation, which is called Zertifizierer Mediationsausbildungsverordnung. So that's the regulation you have to follow. And that was only issued in 2017. So since then, you can call yourself certified mediator if you do have a training of at least 120 hours on defined content areas. There is a long list with 6 hours on law in mediation, 6 hours in I don't know what. A lot of that theory, but also role plays. And you have to have performed one mediation within subsequent supervision of that mediation. All that needs to be documented. And once that is done, you can call yourself a certified mediator. In Germany, or Germany has not signed the Singapore Convention on Mediation, I would say yet. I was part of a forum under the leadership of the Ministry of Justice in Germany discussing the Singapore Convention. We had agreed on the text. Nevertheless, as most of the European countries, or I guess all of them, we haven't signed the convention yet. Now, this was the legal framework. The second one is, let me just try to switch. Yeah. The second one I want to talk about is the use of mediation in Germany. First of all, we have a widespread use on all kinds of disputes, whether it's legal disputes or not. That was already the case before the introduction of the Mediation Act. So that is a little bit different to Turkey. It was established and well known in Germany, and we just put the act on top of it. Now we know the boundaries, the limits, or the rights and duties of the parties a bit more, but it didn't change that much in the use of mediation in Germany. It can be used completely separate in no connection with any legal proceedings, for sure. So that can be done. It can usually be done before legal proceedings in an escalation mechanism. So first negotiation, mediation, and then court proceedings or arbitration usually. It can also be done at a legal proceeding, especially in court proceedings. We have the possibility that the judge refers the case to a mediator. The mediator in court is called Güterichter, but he can use the method of mediation, which is stated in the law. We also have the possibility to do it in parallel to legal proceedings or arbitrations, which is called mediation window, that can be used at any time during those pending proceedings. And my specific area is business mediation. And as Jean-Christophe said, I'm a founding member and also a board member of the Roundtable Mediation and Conflict Management of the German industry. We have started already in 2008 with that, discussing all the issues. So as you can see, that was prior to the Mediation Act. We influenced the Mediation Act as well because we are the users initiative from the industry. And we cover two sections of the use of mediation: the internal use for labor disputes, shareholder disputes, all kinds of internal disputes within a corporation, or external conflicts, which are usually B2A, which is business to administration or authority, B2B, and B2C. And we are very much focusing on B2B mediations, and we have a long lasting experience in B2B mediations, and we developed for that kind of conflicts a specific tool which helps the parties to identify the right dispute resolution mechanism for the case at hand. Because Jean-Christophe, you said mediation is it, that's the one. Yes, in most cases it's a really good solution, but there are a couple of cases where other dispute resolution mechanisms fit even better. And in order to identify the right one for the case at hand, we have developed a tool which can be used by everybody free of charge. It's on our internet under www.rtmkm.de. Anyway, so that's in the call. The tool is called Direct Dispute Resolution Comparison Tool. So that's it on mediation in Germany. Thank you. Back to you, Jean-Christophe.
You have to unmute, Jean-Christophe.
So I thanked Ulrich for his very interesting insights in the German perspective. And now we're going on to the French perspective with Didier MORFOISSE. Didier MORFOISSE is the president of the Association Nationale des Mediateurs. He has 40 years in HR experience. He's been teaching negotiation and mediation at Sorbonne University. And more recently, he's participated and organized over 200 debates with yellow jerseys. You know, all that debate that was going on in France about political citizenship. So it's very interesting how they covered and assisted in that very delicate situation. Please, Didier, share with us the French perspective.
Thanks. I'm really happy to be part of the panel today. First, a very quick perspective on mediation in France. Well, you can ask yourself, is there a space for mediation in France? Considering that we French are keen on disputes and over-regulation, is there a space for mediation in France? In France, you have today between 6,000 and 8,000 mediators. And the fact that I'm not able to give you an exact figure shows clearly that we do not have, as you have in Switzerland, an umbrella institution to cover all the mediators. The landscape of mediation in France is extremely diverse. We at the Association Nationale des Mediateurs are the oldest independent structure of mediation in France. We were created in the year, in fact, of the famous 1995 law on mediation in France. So we are the eldest one. We have, depending on the exercise, on the fiscal year, between 800 and 1,000 individual mediators being member of the association. We also shelter 50 associations. And so to come back to the general landscape, I do consider that mediation, although it was introduced in the French legislation in '95, France is still, in terms of mediation, in the infancy, in the childhood age. We have to deal with the contradiction of the legislator in the way the legislator and the public authorities do consider mediation in my country. On one way, they are insisting and pushing the association to organize themselves and create our own rules to be sure to present trained and professional mediators to the citizens and to the stakeholders. We have, for example, we have not yet an umbrella structure, but some sort of confederation of structure called Mediation 21, grouping approximately 70% of the mediators in France. And we have decided by ourselves the name of the game. And the name of the game, I was comparing to what Ulrich was saying in Germany, is to be considered as a mediator, to have first 200 hours of initial training and a certification at the end of this 200 hours of training, plus a commitment of the mediators to follow at least 30 hours of annual training during his or her practice, and within these 30 hours, at least 10 hours of supervision. So, we found ourselves sort of trapped in this contradiction, because on one way, the government was asking us, the association, to be serious, and I think we've been serious. And in the other hand, when the law was passed, that was 3 years ago, on the qualities to be a judicial mediator, the text was only mentioning, quote unquote, experience slash training, without any figures or numbers. So on one way, on one hand, government is asking us to be serious. On the other hand, when they come out with a text, for example, the qualities the qualification to be a judicial trainer, is absolutely nothing but, quote unquote, training and experience. Noting the fact that the judge can select somebody outside of the list without any qualification possible. So to come back to the yellow jersey, I don't know if you have my slide on the gilet jaune. Jean-Christophe, I can't hear you. No. If you don't have my slide, I will talk without it. No problem.
Yeah, you start and I'll pull it up.
Okay. So the question arose in '98 when the French were facing a tremendous unrest movement in the country that we have called the yellow jersey, les gilets jaunes, because they were covered with the safety yellow jersey that everybody is supposed to have in his car. So if you have the slide on mediation and politics, I'll be very happy to comment it, Jean-Christophe. So in 98, heavy social unrest in the country. I've counted the number of wounded. There were 344 people wounded during the demonstration in the country. 3 million demonstrators. The country totally at stop. They almost they almost succeeded in entering the Élysée Palace where the President of la République stands. Thanks, Jean-Christophe. So the question was, thanks a lot, Jean-Christophe. The question to us was, is there a space, a reason, are we competent, we mediators, to intervene and try to do something in an unrest social movement of that size in the country? And believe me, there was quite a discussion among the members of my association. Should we go? Should we do something or not? A lot of colleagues said, Didier, we shouldn't be part of that. There's a high risk of manipulation from the government. This is not the place for a mediator. We are not the fifth wheel of the government. And I said to my beloved mediators, we're not even the 6,000 wheel of the government. We're nothing. So what we want to do through that, it give an idea of who is a mediator for the normal citizen, for the normal mayor, for the basic backbencher of parliament. They don't know about it. I remember a conversation with the Ministry of Justice telling me, I don't know the difference between arbitration, mediation, and conciliation. So do your homework first, but I don't know what it's about. I don't know the difference.
No comment.
Yeah, the basic idea was make mediation known to the community in a very difficult, in a period of unrest in the country. So among the colleagues, the decision was taken to participate, knowing the fact that it was not mediation. It was an opportunity to have mediation and mediators being known and discovered by the basic citizen. And it's also, and we bet upon the fact that who is best trained than a mediator to moderate a public debate. I mean, we have the training to do that, even if it's not mediation. It's listening, moderating, and trying to avoid manipulation and help people, help people define something that could be useful afterwards. So we organized in the country 200 debates. So we were the biggest, I would say, contributor to the so-called Grand Débat decided by the President of la République. And it was an extraordinary experience. People knew that nothing really, the output of these debates would be manipulated by the government, but they wanted to be heard. They wanted to talk, and we did. It was called local initiative debates. So we did debates in small cities with all kinds of people, even with at the request not only of the authorities but by yellow jerseys themselves. And we followed and completed a quantitative and qualitative approach and report. We were auditioned by Parliament at the end. And I wouldn't say that the number of members of my association rose immediately after the Grand Débat, but we managed to be known and perceived as a peace agent by the French. So it took us quite a time, we really worked on designing the process, on reporting, and I mean, we will be trying to continue in that kind of spirit in the future, because we think that mediation is not only about family mediation, about business mediation, about judicial mediation, but it's a tool of it should be a tool of social peace in the Western world, where we know we are facing now not unified countries, but totally disrupted communities living in the best of the case side by side. So basically that's it.
Congratulations for that huge effort of having, you know, faire rayonner, as you say in French, la médiation with civil society. I think that's wonderful. Dr. Natasha Tunkel is next. And what can I say? I mean, Natasha is an accomplished academic. She has not only studied, but done a PhD in law, especially I think on civil procedure law at University of Vienna. And for years now, I have known her because we met through the VIC, the VIS arbitration moot. And that friendship has stayed on for over all these years. And now we find ourselves not only in the field of arbitration, but in the field of mediation. She's very involved with the Vienna International Arbitration Center, who organizes the CDRC, the Consensual Dispute Resolution moot. She's still very engaged with this arbitration moot competition, with the ICC mediation competition, and is giving time as a mentor also to train young mediators. And so it's with much pleasure that I welcome Natasha to this roundtable today. Natasha, the floor is yours.
Thank you, Jean-Christophe, for that very warm introduction. It's my pleasure to be here today. Thank you to both you for inviting me, and also to Franziska for having this whole panel here. And also thank you to all the speakers who've gone up front, because I'd like to add on and tie in the Austrian perspective to what's already been said. And in that context, I think the first thing to say about where does Austria stand in terms of mediation is that ultimately it's been a very dynamic, but also perhaps natural process in Austria. In terms of the fact that in Austria, mediation started being an issue around 1996, where we had the first pilot projects in courts in regional capitals, so Vienna and Salzburg. And in those pilot projects, mediation, without actually having that firm name, but as a concept, was introduced in family matters, because it was felt that in order to, handle those situations better, especially in divorce situations, especially where children are involved, it might take more than the court setting. And that was one of the initial impulses when mediation actually entered the scene in Austria. And that was continued actually on a number of other levels, which I think a lot broader than what we're talking about here in terms of commercial or B2B mediation. There are similar projects, and they are also ongoing in the area of restorative justice. So looking at potential mediation scenarios which are intended to reconcile a victim and an offender when it comes to small and petty crimes. So that's a lot of a broader context, and that also was started in the 1990s. So not surprisingly, we were up front and in the first row, not only recently, but 2003, 2004, with our first act on mediation, which is related to civil cases in general. And I think the interesting thing in that legal framework, you just have to keep in mind that framework was brought out before the European Union came up with its framework later in 2008, but has actually most of the aspects in it has been adjusted slightly only afterwards. And in that legal framework, I think there's two main points I'd like to emphasize. The one, because we've all been talking about mediators, who are obviously a dynamic part of the process, and their qualification. I think Austria was not only an early adapter, but really went all the way when it comes to qualification. If you wish to call yourself a certified mediator in Austria, you actually have to have 365 hours of training, which is a lot. It's only reduced somewhat to 220 if I have this 200 or 220 if you're a lawyer or if you have a degree in psychology. So, if you have either the sensitivity or the legal background, you can reduce the hours a bit, but it gives you an indication that in those 365 hours, you have a lot of aspects that flow in. So you have all the legal competence, you have the process competence, the psychological competence, all of that is covered if you wish to call yourself a certified mediator. You can nonetheless, of course, call yourself simply a mediator without, being certified, and you can act in that way. But in those circumstances, you don't have the benefit of what the law offers in that context. And now I'm coming to two very specific legal aspects. One, I think Ulrich highlighted in the German law that's very similar. That's a confidentiality obligation that's there, which means that if you are a certified mediator and if you're acting in mediation, you cannot be called as a witness in court and you have a duty to secrecy. But I think there's another very important factor, which I think is a very practical motivator why you would go to a certified mediator, and that is it interrupts any time statute of limitations. And I think that's an important aspect, because how often do we see that clients, I'm also a qualified lawyer, so clients turn up quite last minute when it's already getting tight. And it's an important aspect to know that you can actually engage into a meaningful discussion, into mediation, without the pressure of knowing that if you don't act quickly, your claim may be time barred or similar. That really takes a burden off many clients' shoulders. And so that's also something that's regulated by law, but it's also something that is only triggered if you have a mediation with a certified mediator. I think in other terms as to the legal framework, I'd just like to give you a few highlights and sketches as to where mediation is used. We do not have or at least not to the same extent, the mandatory mediation that Vahit has already described, and I'm pretty sure that Federico will also be describing to us, knowing Italy. That is not the same concept. We have only certain very limited areas where mediation is foreseen as an option that should be considered prior to moving to another step. That is, for example, in certain very specific areas of labor law. Especially one of the classic examples is in an apprenticeship situation. So you actually, have both an employee situation combined with apprenticeship. Before there are issues there, before such a relationship is dissolved, you need to go into mediation to try and clarify the situation. Similar in various other areas, but those areas are actually quite limited. The concept has more been to encourage mediation. If you are, for example, in a divorce situation or family law situation, you will, in many cases, be able to receive support if you go the mediation path, financial support also, which is an important aspect. But otherwise, Austria has taken a quite strong stance on the fact that mediation should be a voluntary process. And however, it's tried to make the scenario attractive, and perhaps that's already transitioning me over to how is it lived and how is it practiced. The offer is there. We have very highly qualified, certified mediators available, and those are actually presented to the market, not only in presenting themselves, but for example, the courts encourage this in the same way. So it's absolutely possible if you go to a commercial court and you have a situation where you have a dispute already filed, that the judge will suggest to parties to consider mediation. And that is done quite simply by inviting a mediator to, if necessary, explain to the parties what the process is about and invite them to engage in it. There are, however, contrary to other countries, no cost consequences if you don't accept that offer. It's up to the parties to decide, but it makes it so easy to enter into the process because somebody is there and you can actually engage, and it's literally up to the parties, and there is no pressure whatsoever. Perhaps also a point to keep in mind, the justice system in Austria in general is an efficient one, so parties quite like to resort to the courts. I act as a lawyer. My first instance proceedings, unless they are very evidence heavy, are usually conducted in a highly efficient and very quick manner. And it's even faster the further up you go in the instances. If you really go all the way, the Supreme Court has decided within 4 months. I mean, that's really no time. And so time is not necessarily the debate, or the issue that parties consider when they opt for mediation. It's really, do we need an alternative, and is this alternative attractive for other reasons? So that's perhaps a different dynamic as to how mediation is implemented in Austria, probably both because of a quite long tradition on the one side, and on the other side because there's no structural need. It's simply an additional tool in the toolbox which might be more attractive and useful for parties. And about talking about attractiveness and usefulness, I'd like to tie on to what Didier described regarding Gilets jaunes, which I really chapeau. I think it's an excellent initiative that you made, but we've seen similar, but not of course as weighty, but we've seen similar in Austria as well. And I think it's also important food for thought about where and how can you use mediation in the public process. And we've had 2 mediations which are public, so I can speak about them. And the one was actually one of the largest mediations ever conducted in Europe, which was regarding the the airport in Schwechat, where it was being extended, and it was a huge issue with all the neighboring communities, because obviously if you broaden, I'm trying to think about, somebody help me here, Piste. The
landing strip.
Thank you so much, Ulrich. The land, they were building a big additional landing strip, and the whole community was in uproar. There were a number of stakeholders for very many reasons. So the neighbors, but also environmental concerns, business concerns, obviously, because this was also tied into the fact that Vienna is an international hub and also a business hub. So, you want a lot of flights coming in. Footnote, this was before COVID. I should probably say that, but you won't be surprised. But all of that being said, this was one of the largest mediations that was conducted. There were over 50, I'm going to say, stakeholders in terms of community stakeholders, but behind those 50 were another 100 each. So it was a very, very large undertaking, but it was successful. It was successful to the extent that they could actually come to agreements on how to take, environmental measures, how to reduce noise, what time slots would be good for flights and similar. It's a very hands-on result that actually came out of this process. And I think that's one of the aspects we should keep in mind where mediation has a larger effect than simply, B2B. And the other one is, and I find this is also surprising, but we had a very large investment case pending regarding wrong information on investments, and that was also settled in a mediation with all the small claim investors represented by a consumer organization, and they went into mediation and then clarified and settled the case in mediation. So I think that's just also another interesting aspect to take into consideration where mediation can be useful. That's food for thought. I'll leave it there and welcome any questions anyone might have.
It's wonderful, Natasha. Thank you so much for the Austrian perspective. And I forgot to say that Natascha has been working for the last 5 years with KNOETZL, which is a Vienna-based law firm, and she's a partner there. Federico Antich with the Italian perspective. So Federico graduated at the School of Law of University of Florence, Italy, and earned an LLM in the US and a global business law at Suffolk University Law School in the USA. After having completed a postgraduate studies at Harvard Law School, at University of California in Davis and University of California in Berkeley, and at King's College, UK. He practices as an attorney at law in Florence since 1997. And since 1999, he also practices as a civil and commercial mediator and is currently accredited by many organizations, including the Center for Effective Dispute Resolution, CEDR, the International Mediation Institute, IMI, and has been the first Italian to be inducted in the Distinguished Fellow of the International Academy of Mediators, IAM. He currently serves as president of the Italian delegation of the Mediation Center for Europe, the Mediterranean, and the Middle East, CEM, and as senior vice chair of the International Committee of the International Bar Association, IBA. He is also a member of the Chartered Institute of Arbitrators, MCI-ARB, and since 2004, he has been involved in teaching the theory and practice of non-contentious dispute resolution, having also received certification as a trainer of trainers in mediation by CEDAR, by Mediation Works Incorporated in Boston, MWI, and as a trainer in higher education by the Derek Box Center for Teaching and Learning at Harvard University. I'm speechless. Federico, the floor is yours.
So thank you, JC, and the Swiss Federation of Mediation Associations for inviting me today. Italy has been on the forefront of modern mediation for quite a long time. And with the enactment in 2010 of Legislative Decree 28, the country received a further push towards a general acceptance of this ADR tool by introducing it as a condition precedent in a wider field of civil and commercial disputes. 10 years have passed now, so I thought it would be interesting to review how mediation has evolved and what are its foreseeable trends in the near future. As you can see on the slide, the development of mediation in Italy has reached a statistically manageable character, and it is noteworthy that the country Minister of Justice is among the few EU member states to collect, maintain, and publish these statistics, providing the figures also in English. So the first figure on the top left side shows the numbers of proceedings treated in the 10 years period observed. The following one on the right provides evidence of the major impact of the mandatory mediation provisions, especially those provided by the law, with a significant growth also of those that are court referred. Sadly, mediations carried out on a voluntary basis did not reach the significant numbers and even decreased in the recent years. The success rate displayed for the 10-year period on top right, and with regard to the year 2020 on the bottom left of the slide, looks promising, though with large space for increase, given that when parties agree to stay at the mediation table after the first mandatory meeting, the success rate reaches 47.8%. The final chart shows how the mediation market is currently divided. Here, the major players in terms of proceedings carried out are the local bar associations, followed by private organizations and the chambers of commerce. These latter showing, however, a better success rate, probably due to their past role of scouts in the field back in the early 90s that allowed many of them to deploy much more skilled personnel and mediators. Taking now a look at the future, I would say that in a statement to the press released just a few days ago, the Italian Ministry of Justice and former constitutional judge, Professor Marta Cartabia, said that one of her goals is to reduce the length of civil trials by 40%. In fulfilling that goal, Professor Cartabia set up on March 12th this year a study commission composed of several professors and experts. The commission recently published its final report, and the government has now submitted its proposals to the parliament, where it will be open to debate and vote by the end of July. With respect to mediation, among the alternative instruments being considered by the works of the Commission, the main innovations proposed can be summarized as follows. There will be significant economic incentives and tax exemptions for parties who choose mediation, including a provision of legal aid for costs related to the legal representation throughout the mediation process. It will also be considered the requirement of personal participation of the parties at the mediation table, the extension of the mandatory first meeting as a condition precedent to litigation to a larger set of matters than those already existing, such as disputes relating to agency contracts, joint ventures, consortiums, franchising, labor disputes, private disputes involving public entities, and even partnerships and subcontracting agreements. Strengthening of court order mediation provisions already existing by incentivizing the referrals when they bring litigation to an end. It has also been considered a limitation of liability for representative of the public administrations when they are parties at the mediation table. It has also been considered raising the quality requirements of mediation providers, of mediators, and training entities. It will also be considered the increase in training hours for basic and refresher courses for mediators. So if this reform will be approved by Parliament, mediation could have a chance of developing further, bringing the benefits of effectiveness and a more efficient way of resolving disputes to a larger basket of beneficiaries. And I think that this is all on my side. Thank you very much again.
Look at our watches. We've spent 1 hour of quality time on that. And if you're okay, I'd like to wrap up. And thank you very much for the availability today to spend some time from a Swiss perspective, looking at our neighboring countries. It's been extremely enriching to hear all these different perspectives and the very advanced, I would say, perspective of Turkey in terms of mandatory mediation. And I would wholeheartedly like to thank every one of you for having shared all your insights. Thank you very much.